All rise. Veuillez vous lever. The International Criminal Court is now in session. L'audience de la Cour pénale internationale est ouverte. Please be seated. Where was this?
Thank you very much. Court officer, please call the case.
Thank you, Mr. President. Situation in the Republic of Kenya in the case of the prosecutor versus William Samoei Ruto and Joshua Arap Sang, ICC 01090111. We're in open session, Your Honours.
Thank you. Appearances?
Morning, Mr. President, Your Honours. For the prosecution, appearances are the same as yesterday.
Good morning, Mr. President. For the victims, the appearance remains the same. Thank you.
Good morning, Your Honours. Mr. Sang's team remains the same.
Mr. President, Your Honours, good morning. Mr. Ruto's team remains the same, and as before, Mr. Ruto is here in court.
Thank you. We also note that from Nairobi we can see Mr. Mutai, so I note he's present, but Mr. Debre I do not see, so I take it he's been excused. The Chamber will now render a ruling on Mr. Mutai's application for the postponement of the witnesses' testimony that was scheduled to commence yesterday, the 1st of September 2014. The application was to postpone it for 21 days. The Chamber has taken note of the preliminary assessment provided by the VWU, as well as the submissions of each of the parties and participants, including those made on behalf of the witness. The Chamber notes that all appeared to be in agreement that some period of postponement was necessary in the circumstances prior to the commencement of the testimony, to the extent that the testimony could not fairly commence yesterday as scheduled. The Chamber hereby therefore grants in part the application for postponement of the witness's testimony, but the Chamber directs that the testimony shall commence on Thursday, the 4th of September 2014 at 9:30 a.m. The Hague time, which we understand to be 10:30 a.m. Nairobi time. The purpose of granting this postponement of a further 2 days is in order to enable the VWU complete its familiarization process with the witness, as well as to enable counsel to prepare. In the circumstances at hand, the Chamber considers the familiarization process to be an important aspect in preparing the testimony for the witness, in particular in order to minimize any stress experienced or to be experienced. Further reasons for this decision will follow. However, in light of this ruling, the Chamber will address a number of related matters. First, it is noted that with effect from yesterday, Mr. Mutai has been provisionally included on the list of counsel admitted to practice before this court. He is therefore formally permitted to represent the witness. It is not necessary for other counsel to be appointed to represent this witness for the purposes for which duty counsel is assigned to him. The Chamber notes in this regard that Mr. Mutai is bound by the Code of Professional Conduct, not only of his own native bar, but also the Code of Professional Conduct for counsel appearing before this court, and in particular obliged to uphold and respect the confidentiality of information in accordance with the statutory framework of the court. Consequently, the Chamber now considers it appropriate for Mr. Mutai to be provided with a copy of each of the witnesses' statements. The Chamber therefore directs the VWU, in cooperation with the OTP, if necessary, to provide such material to Mr. Mutai. Secondly, regarding the scope of representation of the witness, the Chamber considers it appropriate to clarify that the scope of Mr. Mutai's permissible representation of witness 604 is limited solely to the discrete question of possible self-incrimination by the witness and to advising the witness in respect of the applicable provisions in that regard. That fact also informed the Chamber's decision regarding the length of preparation time that the Chamber considered appropriate to grant. For this limited purpose, counsel will be permitted to be present while the witness is testifying and may, with the leave of the Chamber, make representations on behalf of the witness in the context of Rule 74, if required, at appropriate junctures. However, it is not the role of the appointed counsel to otherwise direct or of the witness in any other manner. In respect of the issue of self-incrimination, it is noted that it would not appear from the substantive statements of the witness that significant issues of self-incrimination arise. Nonetheless, as noted in the submissions yesterday, such issues may arise in the context of certain subsequent developments in which the witness was involved, including the apparent sworn recantation of the evidence he provided to the prosecution, and potentially certain contacts he may have had with other witnesses. The Chamber notes that where necessary, an assurance pursuant to Rule 74 of the Rules of Procedure on Evidence can be provided to a witness in order to enable that witness to testify truthfully without fear of the consequences of self-incrimination. Such an assurance would, as specified in Rule 74, Sub-Rule 3C, be with regard to maintaining the confidentiality of the witness's testimony and providing an assurance that the testimony would not be used directly or indirectly against the witness in any subsequent prosecution by the court. It is recalled that the court cannot provide any guarantee against protection in domestic jurisdictions. However, in order to give effect to such assurances, measures including the hearing of testimony in camera, the protection of the identity of the witness, and the placing of relevant transcripts under seal can be adopted. It is noted that an assurance under Rule 74 would not ordinarily cover any Article 70 offences. In the case at hand, the Chamber would anticipate that Article 70, Sub 1, A, B, and C are the only provisions which might be of potential relevance. Article 70, sub 1A and B relates to offences of providing false testimony, that is, committing perjury before the chamber, or presenting evidence which is known to be false or forged. There is no exemption from those provisions. However, provided that the witness tells the truth before the chamber, he need have no fear of incurring liability under them. Article 70, sub 1C of the statute relates to, amongst other things, corruptly influencing a witness. The chamber notes that the prosecution has indicated and undertaken that any evidence provided by the witness before the chamber in this case will not be used by the prosecution against him for purposes of subsequent prosecution, with the exception of offences indicated in Article 70, sub 1A and B, which concern, as indicated earlier, the offence of perjury or providing false evidence before the chamber. It is understood that this undertaking would cover the use of the witness's testimony in relation to any conduct potentially falling under Article 70, sub 1C. At any rate, the chamber rules that information provided by the witness during his testimony before this chamber may not be used in any subsequent prosecution against him, pursuant to Article 70, sub 1C. Moreover, the chamber will maintain control over the scope and manner of questioning of the witness, where it appears to the chamber that any question may implicate the provisions of Article 70, sub 1C. The chamber will carefully consider the necessity and relevance of such questions to the determinations to be made ultimately in the present case. Where appropriate, the chamber will curtail the questioning of the witness to avoid creating unnecessary risk of self-incrimination in areas which the chamber does not consider either strictly relevant or necessary to its assessment of the evidence of the witness or to the central matters for determination in the present case. Although no specific request for Rule 74 assurance has been made, in light of the circumstances and the submissions received, the chamber considers it appropriate to provide a ruling on the matter at this time. On the understanding outlined above, which may, if appropriate, include the chamber directing the questioning of the witness in any manner which limits his exposure to the risk of self-incrimination, the chamber considers it appropriate to provide Rule 74 sub 3C assurances. In reaching this determination, the chamber is mindful of the factors specified in Rule 74 sub 5. Consequently, the chamber orders that for any part of the testimony of this witness where issues of self-incrimination arise, the evidence shall be given in camera, that is, in private or closed session. The identity of the witness and the content of such confidential testimony shall not be disclosed or used in any manner, except in any proceedings which may be brought against the witness pursuant to Rule 70 and 71 of the statute. However, as noted above, these provisions or these purposes, for these purposes, the undertaking of the prosecution and the chamber's ruling are understood to also extend to matters potentially falling within Article 70 sub 1C of the statute. each of the accused, counsel, the parties, participants, and court staff present or otherwise with access to the evidence are hereby specifically cautioned that breach of this order may result in sanctions under Article 71. The relevant confidential transcripts of the evidence of this witness will be placed under seal, and the court would apply appropriate protective measures to any subsequent decisions in order to give effect to this order. It will be primarily the responsibility of the parties to ensure that all questioning which may touch on aspects of the witness's evidence likely to give rise to issues of self-incrimination is conducted in private or closed session. The witness or counsel on the witness's behalf may, in the same manner, also request private or closed session if it is anticipated that an answer to any particular question may give rise to self-incriminatory testimony. Counsel is directed to ensure that the witness is fully informed of and understands this ruling prior to the commencement of his testimony. Finally, restrictions on contact with witnesses before and during their testimony would apply in respect of witness 604, including to counsel for the witness. In particular, consistent with the Unified Protocol on the practices used to prepare and familiarize witnesses for giving testimony, adopted in this case according to the decision on witness preparation, once the familiarization process has commenced, there should be no contact between the counsel and witness 604. In particular, counsel will be excluded from the process when the witness rereads his statements. That familiarization process will be conducted with the witness solely by the VWU. The Chamber recalls that yesterday it directed the VWU to commence familiarization, and therefore these restrictions apply with immediate effect. The one exception to this prohibition on contact is that the VWU may facilitate counsel meeting with the witness for the purpose of providing advice and explanation relating to Rule 74 matters, as just outlined. As regards contact during the actual testimony, the Chamber is of the view that the restrictions applicable to the parties need not apply to counsel for witness 604, and that some contact should be allowed. The Chamber finds it appropriate to allow contact on the conditions applicable to the legal representative of dual status witnesses. Accordingly, counsel should refrain from holding any substantive discussions with the witness about the topics that are to be dealt with during his evidence or the exhibits which may be produced. Discussion with the witness about this testimony may only occur after the close of the evidence in the case. Moreover, the basic principles for contact with witnesses as set out in the witness preparation protocol shall apply in respect of any contact, whether before or during his testimony with witness 604, including any contact with counsel. These principles prohibit coaching, training or practicing of testimony, as well as any attempt to influence a witness to testify to factual events that the witness did not observe or perceive. This concludes the ruling of this Chamber at this time.
I'm grateful, Mr. President. And could I ask, we haven't had sight of the VWU assessment. I wonder if you could order that that be provided to the defence. I'd be grateful.
Mr. Steinberg, did you receive that?
No, Your Honour. For the record, I haven't received it either.
Right. The Chamber directs that the VWU is to make available the preliminary assessment. I have been reminded that typically this doesn't go directly to the parties, but the chamber may indicate what it is that the VWU had indicated in their preliminary assessment. They indicated that the witness's condition does not prevent him from giving testimony at this time. That was the preliminary assessment. So the VWU then need not directly send this information to the parties. I've already done that.
I'm grateful.
Thank you, Your Honour. Your Honour, may I seek the Court's indulgence just to clarify one matter in Your Honour's finding that appears at page 9, line 22, where Your Honour said, discussion with the witness about his testimony, this is referring now to duty counsel, discussion with the witness about his testimony may only occur after the close of the evidence in the case. I presume Your Honour didn't mean the close of all evidence in the case, but the finalization of this witness's evidence. Am I correct?
That is indeed the case, the understanding.
Thank you, Your Honour.
Now, the next item on the agenda would be the submissions of counsel, again, related to the witness. The I think now 80 documents that the prosecution wishes to add on the list of materials that they would like to use during the examination of this witness. For that exercise, the witness and counsel in Nairobi are excused. It will not be appropriate for them to be part of the discussion at this stage. So we may then thank Mr. Mutai for having joined us so far. So we'll see him again on Thursday.
Many thanks, Mr. President. We shall be present on Thursday.
Thank you very much. All right, prosecutor and counsel, we will take submissions on that matter. We will begin with you.
Thank you, Your Honour. Your Honour, the prosecution has made fairly complete submissions in its application pursuant to Rule 35(2). That's filing number 1463, confidential. As expanded upon in its reply to the defence response, filing number 1471, which was submitted with the leave of the Chamber. Your Honours, in addition, the prosecution has submitted an addendum to the filing, which is filing 1474, which doesn't deal in any detail with the legal submissions, but rather is confined to the relevance of the additional documents and submissions regarding prejudice or the limited nature of the prejudice to the defence. Perhaps I can just commence by reiterating the reasons for which the prosecution seeks to add these documents, since they appear to have been the source of some conjecture which is not in line with the prosecution's wishes. And I am aware that we are in public session, so I will have to temper my language, and maybe from time to time that I may have to ask to go into private session. The first purpose for which the prosecution wishes to submit this list of documents, or these additional documents, and to have them added to its list of evidence. Well, perhaps I should just start with the provenance of these documents. With the exception, I think, of 2 screening notes, the remaining documents are all documents which arose or have been produced subsequent to the commencement of the prosecution's case. The majority of the documents have arisen in the context of the OTP's investigations into what it alleges is a concerted and organized scheme of interference with the prosecution witnesses, which scheme we submit has been the root cause of the necessity for the Chamber to summons the 9 witnesses who are presently the subject of summons in Kenya, as well as 2 further witnesses who are outside of Kenya and who the prosecution seeks to invoke compulsive measures to ensure their testimony. Your Honours, this course of events and this unprecedented attack on the integrity of the court, which the prosecution submits as occurred, runs the risk of depriving this court of much of the relevant and necessary evidence which the Chamber will require in order to reach the truth, to discover the truth, and to reach a proper finding in this matter. As a result of this interference, many witnesses have withdrawn cooperation from the prosecution, have refused to testify voluntarily, and we submit have falsely recanted their earlier versions that were given to the prosecution in witness statements. The defense, I'm sure, will hotly dispute that fact. The defense's narrative is that these witnesses, or a number of these witnesses in any event, are witnesses who were induced through promises of financial gain to falsely incriminate the accused. And the reason why they are now recanting is presumably because their conscience has got the better of them, or they fear discovery, or they fear prosecution, or some combination of the above. The prosecution's version, of course, is that their initial statements were true, and their recantations have in fact been bribed by promises and indeed payments of substantial sums of money in the form of bribes, coupled with a systematic intimidation of witnesses, witnesses' families, and a general atmosphere of hostility existing in Kenya towards the ICC and towards ICC witnesses. Now, the first purpose for which the prosecution therefore seeks the admission of this evidence on its list of evidence is in order to confront, where necessary, witnesses who now recant earlier statements given to the prosecution. Now, it is not the prosecution's practice to take statements under oath. Indeed, there is at least doubt as to whether the prosecution has the ability to administer the oath, but these are certainly statements that are solemnly given for the purposes of future evidence before court. Where witnesses have disavowed these earlier statements, the circumstances under which they have come to do so is, in the prosecution's submission, undoubtedly a matter which should be of great interest to the Chamber. If it can be demonstrated that these witnesses were interfered with, either through threats, coercion, or inducement by payments, that is indeed, in the prosecution's submission, a factor which will be extremely relevant for the court to determine whether their recent recantations are in fact the truth, or alternatively, whether the recantations are false, which, in my submission, through the normal process of logic and experience, would tend to suggest that their initial versions are more likely to be true. One could observe that it is hardly likely that someone will spend time and energy to locate, track down, approach, and bribe witnesses, as well as the financial commitment involved, where those witnesses are in fact complete liars and will no doubt be exposed as such through the normal legal processes. Far more likely that witnesses who are being bribed because they are a threat, because they have real, cogent, and incriminating evidence. Your Honours, the defence for Mr. Ruto does not dispute the fact that, or does not object to the fact that this evidence may be used to confront witnesses. I understand that the defence for Mr. Sang does do so. But my submission is that in order for the bench to reach an informed decision as to the credibility or otherwise of these witnesses who will come before the court, particularly those who have already recanted, as well as those who, through their withdrawal of prosecution, of cooperation with the prosecution, may well be expected to be at least adverse to the prosecution, if not openly hostile. In order to properly assess their credibility, the Chamber needs to be apprised of the relevant facts which preceded their recantation or their adoption of an adverse position to the prosecution. Now, that's as regards the evidence of a particular witness about him or herself. But many of these witnesses also have relevant evidence about other prosecution witnesses. The fact that they have already been approached or have accepted offers. And the prosecution submits that it is also relevant for the prosecution to be able to lead that evidence, where possible, from one witness in order to use in the assessment of the credibility of another witness. That is, well, certainly it's a well-recognized purpose of cross-examination. And presumably, well, if the Chamber grants the prosecution, in appropriate circumstances, permission to cross-examine witnesses, that would certainly, in my submission, be an appropriate and permissible line of questioning. Thirdly, Your Honours, it is important for the Court, in my submission, to be able to see the broader picture which is emerging in this case. The jurisprudence is replete with rulings and suggestions to chambers that it should not, or that they should not, adopt a piecemeal approach to their assessment of the evidence, but rather each piece of evidence should be seen against the mosaic of the larger evidence of the case. And it is only when the bigger picture becomes visible that often the chamber is in the position to make informed decisions. And in this regard, Your Honours, I submit that the bigger picture will emerge should the chamber permit prosecution to lead the evidence of the nature which it seeks to do. This brings me to the third aspect, and they're all interrelated, and that is that...
But what is the bigger picture?
Your Honours, the bigger picture is that is the fact that it's not just one witness that's been tampered with, or rather, in considering the credibility of one witness and whether or not the court will accept that the reason why that witness has been recanted is because he or she has been interfered with. Similar evidence led in respect of other witnesses may indeed be mutually reinforcing and mutually corroborative. And in that regard, the evidence will have a cumulative effect which would be lost if one only focuses on one witness at a time. And that is why the pattern is an important factor. Moving on then to the assessment of the probabilities, I've already touched on this, Your Honours, but there is certainly in the prosecution's submission a competing narrative which has evolved during this case as to whether witnesses have been interfered with, and if so, by whom and for what purpose. And my learned friend for Mr. Ruto has argued in his response that these are separate issues, that this deals with matters which happened a long time ago, and has nothing to do with interference today. But in the prosecution's submission, these two matters are inextricably linked, again for the reason that it may be logically inferred that one does not waste one's time, effort, and money bribing witnesses who are doomed to be exposed as liars and charlatans before the chamber. There is an additional but important factor which is to be taken into account, and that is provided by the provisions of Rule 68 in this matter. The prosecution has, on numerous occasions, given notice to the chamber and to the defense that should the remaining witnesses who have been the subject of summons or who are anticipated to be the subject of further compulsory measures fail ultimately to come to the court and to testify, despite all reasonable steps having been taken, or should they come and testify and recant their earlier versions, and should the chamber be satisfied that the actions described above are the result or are materially influenced by improper interference, including bribery, the prosecution will submit that under Rule 68, the prior statements of these witnesses should be admitted into the record. The prosecution submits, therefore, that any evidence or evidence of the nature which it now seeks to add is precisely the sort of evidence which the chamber will require to have before it to assess and to either accept or reject in order to come to the conclusions which it will be required to make under such a looming application. It would be more efficient in the prosecution's submission to allow this evidence to be submitted in the ordinary course of examining these witnesses, rather than to separate it out and require witnesses possibly to be recalled or otherwise having all of this evidence reintroduced at a later stage, when it must at least be foreseen as a reasonable possibility that this will be required in due course.
On that note, so that I get a clear picture of what's on your mind to do with these materials. Now we have 80 documents, 57 in your first papers you filed, and then latterly another 23. Do they all relate to 604, or do they address all the witnesses under subpoena?
Your Honours, they are limited to the first two witnesses, 604 and 495. Due to the imminent testimony of these witnesses, the prosecution has prioritized those two. But as indicated in the application, the prosecution does anticipate similar applications in respect of remaining witnesses. As to the number of documents Your Honour has mentioned, many of these documents are single-page investigators' notes. A substantial number of them are simply photographs of annexes to witness statements that are photographs of cell phones, or photographs, in one case, of a meeting. They are not, in the prosecution's submission, extremely voluminous. The majority of them have been disclosed at least a month ago, in many cases, often much more. There are, of course, the prosecution concedes a number that have been recently disclosed because of the fact that they could not be disclosed earlier for a variety of reasons which are set out in the filing. But those are, in the prosecution's submission, a limited and contained number of documents that would not, in my submission, be unduly prejudicial to the defense, in the sense of an unfair procedural prejudice. Obviously, there's always a prejudice when incriminatory evidence is admitted, but that is not the sort of prejudice which we should be concerned with here. Given the importance in my submission of this evidence, and given the limited prejudice the prosecution submits, that the Chamber should, in these circumstances, exercise its discretion to admit the document, or rather to allow the prosecution to add the documents to its list of evidence. Obviously, when the prosecution is leading the witnesses or cross-examining the witnesses, as the case may be, the court has the discretion to allow the prosecution to use the documents and subsequently to admit them or not. But for present purposes, the prosecution submits it has made out a case that it should be able to have access to these documents to use them if they do become relevant. Your Honours, if I may address one discrete issue raised by the defence for Mr. Sang, and that is an issue of jurisdiction. The argument is made out, as I understand it, that this court should not concern itself with these any allegations of witness interference, because these ought first to be put before the pretrial chamber for the pretrial chamber to decide on, for them to presumably confirm charges, etc. The prosecution does not seek to have this chamber prejudge any future prosecution that may occur, if indeed such prosecution does occur. Any rulings which the chamber may make as to the relevance and admissibility and ultimately the reliability of this evidence would not be, in my submission, binding on the pretrial chamber. They will be free to assess that on the evidence before them or before it. And this should certainly not be a bar for this chamber to refuse to admit or to consider evidence which is, in my submission, relevant to the issues, live issues in this case, in which the chamber will need for a proper determination of this matter. Unless there are any further questions, Your Honours.
There's the obvious one. The Ruto defense vigorously indicated a concern about whether you are heading or setting up a case of consciousness of guilt.
Thank you, Your Honours. I obviously did deal with that in our reply, but the purposes for which the prosecution has requested the admission of the documents on its list of evidence I have set out, they do not include consciousness of guilt. I am alive to the undertaking my predecessor, Ms. Tai, gave almost a year ago. In fact, it was probably over a year ago now. I do submit that circumstances have changed substantially, but that it is not my application at this time to have the evidence admitted for the purpose of consciousness of guilt. I do not presently intend to do so. Should circumstances change where I feel I have to do so, that will be the subject of a separate admission, a separate application, and all of the issues which were raised by my learned friends would have to be determined by the Chamber at that time. But certainly at this time, I do not make that application. Thank you, Your Honours.
Mr. Narata, so we can take it in logical manner. Briefly.
Yeah, Mr. President, thank you very much. I see the time.
All right. Would you, I see you set up your diet to speak, so I take it you do have some submissions to make, is it?
Yes, we do have submissions to make.
All right. We will rise now and come back at 11:30.
All rise. We will wait. All rise. We will be. Please be seated. We
are in open session, Your Honours.
Thank you very much. Mr. Nurtete, please.
Thank you, Thank you very much, Mr. President, Your Honours. This is the first time the Victims' Council expressing his views on this litigation. First of all, Your Honour, we support the prosecution's application for the inclusion of 80 items in the prosecution list of evidence. In our view, the prosecution's application raises two questions. One is procedural, the other is substantive one. Firstly, the procedural one, which is the time limit in our observation. In our view, Your Honours, the prosecution's arguments in support of the extension of the time limit for the inclusion of the items in the list of evidence are sufficient. So, therefore, we will not add anything else on what the prosecution counsel already had put forward in writing. Your Honour, the next issue is a more complicated one, which is the substantive issue, in our opinion. This issue is whether the prosecution may use those items. If Your Honour's minded to grant the prosecution request, whether the prosecution can use those items in order to show the Chamber the alleged interference of prosecution witnesses. Your Honour, before going into the matter, we note that parties generally agree that the prosecution may use those items in order to confront those witnesses. But what the parties do not agree is what extent the prosecution may use those items in order to expose certain acts of witness interference. Your Honour, in our respective submission, the prosecution should be allowed to certain leeways to use those items in order to show you the alleged acts of witness interference and the impact of those interference on the credibility of the testimony which these witnesses will bring. Your Honour, this is, of course, corruptly influencing witnesses, of course, in a serious crime under the Rome Statute. Your Honour, proving the commission of those crimes, the offences against administrative justice, is, of course, a separate issue which should be subject to an independent proceedings. But, however, Your Honour, the prosecution had already pledged that the use of those materials, the prosecution will not use those materials in order to show any form of guilt on part of the accused persons. Therefore, Your Honour, in our respective submission, there will be no prejudice towards defence if prosecution use those items in the purpose they seek to introduce. Your Honour, we also note that the prosecution seeks to introduce those items in order to assist the Chamber in making an informed determination about the credibility of the certain summoned witnesses, in particular, the real reasons behind their recantation of their previous testimony. Your Honour, in our view, the credibility of those witnesses, in particular, the question of why those witnesses had recanted their testimony, and, Your Honour, the issue of alleged acts of interference, those two issues, in our opinion, are intrinsically connected. Therefore, we say that these are they are these two sides of the same coin. Your Honour, we submit that there cannot be full and proper and objective assessment of the evidence that these witnesses are going to provide. Without engaging this inquiry as to the circumstances of their withdrawal from the process and the circumstances that forced them to recant their testimony. Your Honour, we submit that by only allowing the prosecution to do this, the candidate court be able to see the whole picture and find the truth. Your Honour, I will conclude shortly. Your Honour, in our view, overriding objective of this trial process is to deliver justice not only to the parties, but also to the victims as well. Justice and truth are inseparable, and justice cannot be done without establishment of the truth at first. Your Honour, it's noteworthy that Defence Counsel has reiterated previously that they want witnesses to come and tell the truth. in our submission, defense cannot now disavow their appeal and shy away from introduction of this evidence, which will assist Your Honors to find the truth in properly assessing the credibility of those witnesses summoned. Your Honor, in conclusion, we submit that the truth, the whole truth must be known, including the circumstances which forced those witnesses to recant their testimony. And we submit that the admission of this evidence in question and the use by the prosecution for that limited purpose would be a step towards to that goal, which is establishment of that truth. Yeah. Thank you.
Thank you, Mr. Naratsetsing. Mr. Khan, you were rising to address before I invited Mr. Naratsetsing. Of course, your first point of call would be that you do not oppose using the material as such, but you have some difficulties as to the extent of it. Isn't that your point?
Indeed it is, Mr. President, and that's the nub of our response to the prosecution application. And I'll deal with that in a little more detail. We do rest generally upon our submissions, which are, in our respectful submission, detailed and set out our position adequately in relation to the prosecution original application. But at the outset, it's only right to address certain points that have been raised today. We do not cavil at all from my learned friend for the legal representative of the victim's assertion that justice and truth are inseparable. That has been our assertion from the outset. There is, of course, a difference between the parties, the prosecution and the legal representative for the victims, once again on the same side, and the defence as to what that means. But the prosecution has repeatedly said, look at the big picture. What is the big picture? The big picture is that 3.5 years ago, Mr. William Ruto had his good name sullied with a summons that was announced as a Christmas present by Luis Marinho Ocampo. The truth is that a year ago this month, a trial started. The truth is 21 witnesses have been brought voluntarily by the prosecution and have had their accounts tested. The truth is that not one victim witness has testified to seeing weapons, and yet the prosecution stubbornly cling to a narrative and seek to summon witnesses that assert 3,000 weapons are given. It must be the first time in history 3,000 weapons are given to youths and not a shot fired according to the prosecution's own evidence, and not one youth seen with a weapon according to the prosecution's own evidence. But, Your Honour, going to the...
Mr. Khan, it may be advisable at this stage not to make closing submissions on the evidence already heard. Let's just deal with the matter before us. Because the prosecution, once you open that gate, assuming we allow the gate to be opened for all to walk in, the prosecution may feel it is right that they also comment on the evidence heard so far. So let's not go there. Let's focus on the material before us.
Your Honour, I will do that, and I will be so advised. And just for explanation, in my submission, the big picture is important, because it is my vigorous submission, and I've said it before. The prosecution realise that this case is going to fail. And I'm asking the court to consider very seriously my submission that what is motivating the prosecution, unfortunately, is not a search for the truth, but having an exit strategy. So when this case is dismissed, or when not guilty verdicts are entered, they will say everything was to order. The case was confirmed, and their imperative at the moment, and let there be no pretense about it, they want there to be a defence case. That's their imperative. Because whenever there's a defence case, in the event Your Honours side with the defence and say there's no case to answer, or, that the case is not proved, the prosecutor, and I can see it, even without a crystal ball, she will say this is justice. There's a not guilty verdict. Judges, we are vindicated as the prosecution because we put a case forward, it was confirmed, we put a case forward and the judges said there's a case to answer. And so the fact that 4 or 5 years of somebody's life have been in turmoil is really a price worth paying. Long live justice. That is the end game of the prosecution. It's creating a narrative now that will excuse their massive systemic failing. And, Your Honours, what has the game plan been? Let's expose it, because it is the big picture. They have said this is about obstruction. Well, yesterday we heard 4 out of the 5 summonses have been served by the Republic of Kenya, the Attorney General of whom has graced this court on at least 2 occasions. So the obstruction argument is revealed in its naked truth as nothing other than hot air devoid of merit. What are they left with? The same old narrative that is going out to the public, to the people of Kenya, that yes, they actually have a case. They've done their job. They have the right man. But bad defence or bad third parties, it's all down to witness intimidation. And that's the narrative that they're seeking to push. Your Honour, my learned friend has said he's cognizant of Miss Cynthia Tai then leading this case, her undertaking, that she did not wish the prosecutor, because it's a unitary office, would not seek to use evidence of consciousness of guilt. Despite being allegedly cognizant of that, it is in our respectful submission revealing, to say the least, that there was not an iota, not a word of mention of that undertaking in the prosecution's original filing 1463.
But Mr. Steinberg has again, prompted by me to address the matter, has also said that he is mindful of what his predecessor in the case had said. I believe Ms. Tai at the time said it was not the intention of the prosecution to argue, make arguments of consciousness of guilt and the manner of witness interference. Mr. Steinberg has said today that at the moment they're not intending still to do that, but then if they do want to make any such case, they will let us know, and you will be given an opportunity to speak to the matter.
In my respectful submission, Your Honour, that's not good enough. It's getting very close to an abuse of the process by the prosecution to renege upon undertakings. And, Your Honour, we set out in our response the undertaking of Cynthia Tai, 1 sentence of it. But Your Honours will have, of course, in due course, look at the transcript. And I jumped up at least twice, said, I'm not clear what is the prosecution doing. And lo and behold, a year later, they are seeking, for whatever words, to do precisely that. Because, Your Honour, contrary to the undertaking of Mr. Steinberg, contrary to that undertaking, and it's revealing, in this case, they filed an application. They've been given leave to reply. And then they filed an addendum. A last throw of a dice, we say, in this case. But, Your Honour, let's look at it. In paragraph 33 of their own filing, which they did not refer to at all in their reply or in their addendum, what do they say? They say this at paragraph 33. The prosecution will argue, no uncertainty, the prosecution will argue at the relevant time that the fact that the existence of a conspiracy to corruptly induce prosecution witnesses to withdraw or recant, if accepted, is a factor that supports the veracity of the original evidence implicating the accused. What on earth is that, if not consciousness of guilt? And the prosecution, in their reply, seek to take issue with our assertion.
Is it the same thing, really, if doesn't consciousness of guilt stand on its own, in the sense that, yes, an accused person has been, there's evidence clearly showing that an accused person has been engaged in a certain kind of conduct. Because the accused person has engaged in that conduct, judges, we want you to infer from that what motivated that conduct was consciousness of the guilt of the accused person. is it the same as saying, well, the witness had given a testimony at some point? Sorry, statement to the prosecution at some point, and had subsequently disavowed that statement, and the prosecution is saying, judges, we want you to inquire into how that disavowal came about. If you agree with us that the disavowal was improperly procured, then we will urge you to disregard the disavowal that the witness gave on the stand and accept what they said the first time in a statement. Is that the same thing as consciousness of guilt?
Well, Your Honour, in my respectful submission, the prosecution application, reply and addendum is characterised by an attempt to be ambiguous on core issues where they're in difficulty. Because once again today, and it's in support of paragraph 33, what did my learned friend Mr. Steinberg say when he was on his feet? At page 15 he said, and one can refer to verbatim, but my note was, it's hardly likely that somebody will spend the time and energy to track down witnesses who are complete liars. Your Honour, again, lawyers are, my learned friend is a very clever man, he's a senior counsel, the prosecution is full of brilliant minds. And of course lawyers can pass words and divide words and give connotations that they want. But what was the nature of the undertaking given by Ms. Cynthia Tai in May 2013, when I was given leave to stand up twice and press home the point? It was very clear in our submission that we did not want this nonsense, and we say it's patent nonsense. It's a smokescreen to pollute this case of witness intimidation. And, Your Honour, we went so far, and again it's pertinent to the bona fides of the prosecution application. We went so far as to say, and it was an application originally, I think, of Mr. Sang, that Article 70 allegations could be dealt with as a preliminary issue. Now, the prosecution were opposed to that. One wonders why. Was it because that their witnesses would be discredited before the case even started? And, Your Honour, why were we doing it? We were doing it because we, and I use these words at some stage, we want to know what the target is. We didn't. We've been blindsided. My learned friend sent an email that over the summer recess there's an amnesty. So we said, okay, we'll agree to that. We will not have filings. There was no courtesy filing. A few days before this session, we are ambushed, we say, ambushed by a new application for the first time stating that they were seeking to add evidence as incriminatory evidence. And the prosecution of vermins that somehow there's no prejudice, and that being repeated by the legal representative of the victim doesn't make it the truth. There is massive, obvious, clear prejudice. What is it? The prosecution say, well, this has been disclosed previously. That's a half-truth. Because firstly, it was withheld from the defence. It was only unredacted the day before the filing, on the 21st of August, I believe. Some of it, important aspects of it, were unredacted on the 21st of August. But, Your Honours, we cannot swim against the tide. We are a small defence team against the power of the prosecution, supported by an assembly of state parties, having all the cooperation of states, including the state of Kenya and other states. We have a right, any accused has a right to know what the target is. And the fact evidence has been disclosed does not give me as lead counsel an obligation to run around like a headless chicken, chasing my tail to find out and ferret out what could possibly be raised. I will focus my energy. I will use the money and the resources provided to me by my client to focus on the allegations raised by the prosecution. And the prosecution did not add this evidence to its list of evidence. They did not say, this is going to be used to incriminate you. And they went so further. When I gave them a chance, what are your intentions? Look at the substance, look at the spirit, look at what Ms. Cynthia Tai was saying. She said, no intention to use it for consciousness of guilt. That would be a distraction. We agree, strangely, perhaps for the first time, with what my learned friend Ms. Cynthia Tai had to say. It would be a distraction, it is a distraction, and it is massively prejudicial to the defence. Your Honour, we also asked...
Before you, Mr. Ken, before you proceed, still on Ms. Cynthia Tai's what she said on the record. She said that before the commencement of this case over a year ago, that she said that Mr. Steinberg this morning expressly said circumstances have changed. Does that mean anything, or ought it mean anything? Let me be specific. Let's say at the time, I would take a hypothetical case, an example, and not so that we don't frighten people in this case. Let's assume this was another case, and Ms. Cynthia Tyler, the prosecutor, before the commencement of the case, said there had been witnesses' interference. We want to bring forth some evidence of that. And the defense said, no, you shouldn't. And the question arose, Ms. Ty, are you doing this for consciousness of guilt? And Ms. Ty said, well, on the basis of what we have now, no. And later, or even doesn't say on the basis of what we have now, no, but simply said no. But events evolved. Subsequent to that, events evolved. And let's say, and again I want to be clear, because we don't have evidence in this case that the accused person is directly implicated in any witness interference. If the prosecution has that case, they will have to make it before us. But let's assume that evidence emerged that in that other case I'm talking about, example, evidence emerged that the accused person may have in fact been implicated. That was subsequent evidence. Would the undertaking given before still bind in that sort of situation?
Well, Your Honour, this is all broadcast publicly, so I will say, for fairness to Mr. Ruto, even on the prosecution evidence, there's no direct allegation at all that Mr. Ruto has done anything untoward. And that needs to be emphasised, because what is happening in this trial, and the way the prosecution has chosen to conduct it, is that a person presumed innocent is being maligned continuously by a narrative, and the reality is not being properly focused. And Your Honour, the other aspect I'd ask the court to bear in mind very acutely is we are at peril, and a reference was made to the victims, we are at peril of losing sight of justice, and losing sight of the interest of the victims, and losing sight of what this case is about, the post-election violence of 2007 and 2008, and going on a wild goose chase on the runaway train that the prosecution would have the bench embark upon to an unknown destination, but that is miles away from the truth. And so we, in the strongest possible way, say that that should not be allowed. Your Honour, in regard to the hypotheticals, I'm not going to pin myself down at the moment, but I will say this. The further one goes into a trial, the more onerous is the responsibility to show good cause and necessity even. And otherwise, the right of an accused to have an expeditious trial is going to be a dead letter. And Your Honour, unfortunately, and I've said it before, and tragically I have to say it again, certain aspects, certain rights that are given to the accused are being rendered a dead letter by this office of the prosecution. And I'll give you one example. In relation to witness 16, my learned friend from Mr. Sang, he's recanted. He was interviewed abroad with an international lawyer present, gave a long interview, and Mr. Sang's team contacted the prosecution and said, what are your intentions in relation to witness 16? Because it's important. His account actually is completely, is largely anyway, supportive of what we've been saying from the beginning. What did the prosecution say there to that uncomfortable truth, that reality of witness 16? They said, Article 54, we're going to investigate it. We're going to investigate. important point, again, I'd ask the bench, or all three of you, to, with the greatest of respect, to hold closely, is the false narrative or the false options presented by the prosecution, that witnesses are presented effectively with two options. You recant, or you stick to your statement. That should not be the focus of testimony, because there may be truths and untruths on both sides. The important focus is a witness telling the truth here before your honours, and let the parties test and challenge and evaluate. And we have said, we're different to Mr. Sang, we've said, your honours, this evidence, let it be added to the list of evidence for the sole purpose of being a reservoir available to the prosecution, that if that scenario is reached, that a witness is declared hostile, and if the court say a witness is not desirous of telling the truth, the court may allow the prosecution upon application to use certain evidence and to exhibit it. And we've done that, Your Honour, because we are not scared of the truth. I am not scared of the truth in this case. But what I have great trepidation about, what I am not sanguine about, is the due process rights of Mr. Ruto, because I fear that we are being sent on a maze adventure into which we will spend an awful lot of time going to a closed door at the end. It is unnecessary to raise these issues. And in assessing...
Isn't your point, Mr. Ken, simply this? Doesn't it boil down to this? That if those documents are going to be used for the exclusive purpose of confronting the witness about any disavowal of statement, you have no difficulty with that. But if the objective is to bring in that big picture of a generalized witness intimidation scheme, it is a generalized picture that has a bearing on the trial of your client, for the purpose of answering the question guilty or not guilty of the crimes charged. Therefore, that big picture may create prejudice to your client, whether or not it was intended so by the prosecution. Is that your case?
Your Honour, largely it's correct that we have stated that it can be used in our submission. We're not opposing evidence. We're not opposing a witness being tested. We're not opposing a witness being challenged. We are not opposed to the truth coming out. We're in favour of all of that. What we're saying is the prosecution assertions that this can be used to show general prejudicial evidence that the defence has not investigated, that we're not able to challenge, is massively and grossly prejudicial. Your Honour, the prosecution have said in their filing that this is the tip of the iceberg and that they are going to make other applications for other witnesses. We're deluged, in fact, just before the new session with these applications, the new documents, to analyse it and look into it and decide what strategy to approach and how it can implicate on us. And, Your Honour, if the prosecution application is allowed, it's going to require significant months of delay for me to start investigating a collateral case. And from the beginning, I think it was one of the phrases used, the shadow case. And we were told that that shadow case would not be presented. And it seems, no, it's not a shadow case. That shadow case is becoming the main case, and we're losing sight of the PEV case. And that's my concern. Your Honour, the prosecution assertions, and it's been repeated a long time, and I've left it alone because I thought it was quite straightforward and it was premature. But once again, they say there's an ancillary purpose to all of this because it could be relevant to a Rule 68 application. Your Honour, in our submission, that's a bad point. In fact, it's a point even made in bad faith, because apart from the provisions of Article 51.4, the prosecutor was present in the Assembly of State Parties when that rule change was made. She's invited, we're not. But, Your Honours, one can look at the verbatim record and look at the material states put in. There were clear averments made by state party members that that rule change would not affect ongoing trials. And so the prosecution know that, and yet their last throw of the dice again, another option. Put the statements in. Why? Put the statements in, defence don't challenge, it means there's a case to answer, let the justice be done, let Mr Ruto be acquitted in 2 years' time, and the institutions, not the institution, the prosecution's failings will be given a fig leaf by the judges. And that is our very serious concern. We have said this case should not have been brought, and we've said it's not rhetoric. It's because the prosecution have failed to investigate. They have failed to look for the truth. They've looked away from the truth in their interviews. When it comes to witnesses that are like witness 16, they're investigating. When it comes to other witnesses, they want to declare them hostile and put in all kind of other evidence. We say, yes, let them. Let them test their witnesses. Because, Your Honours, these witnesses, 336, Mr Baraza, were prosecution witnesses. They were prosecution intermediaries. The prosecution gave them benefits, not the defence. And when these crooked witnesses went further bad, when these individuals started telling the truth, or at least in part, that's a matter to be assessed. Maybe they're not. But when they went away from the script, the untruths, the prosecution say, well, somehow it's nefarious. Your Honours, it may be nefarious because they have not exercised judgment and caution and diligence in assessing who are witnesses of truth at the beginning. And that's why we're in this lamentable situation. The checks and balances that that office was mandated to apply were not put in force, so they didn't investigate properly their own witnesses. They didn't check verifying facts. They didn't do the basics, and they're saying non-cooperation. Does that excuse not even asking certain basic questions? And that's why now the whole story's moved away. Poor victims. Poor Mr Ruto. On this odyssey of the prosecutor to justify a case that should never have been brought by opening up a completely new case that does erode into the Article 70 jurisdiction of the pre-trial chamber. Your Honour, it's a very sad day, it's a very worrying day, we say, because I'm not sanguine about the intentions here. When one is looking at significant events, the approach to witness 16, the refusing when I asked the deputy prosecutor to investigate one of their witnesses, just investigate for Article 70, the refusal to even consider when Ms. Dato Alagendra and myself met him, even to refuse receiving our information for the purposes of an investigation. They said, no, leave it till the end. Why? Why should the show go on? It's as if the prosecution say it's a bad movie. It's a terrible movie. We didn't pay to see this. But we must sit in through to the end, however painful it is. We can't have our own exit strategy. The judges should be forced to have a defence case, and this is the method by which the prosecution are achieving it. Your Honour, if the prosecution application is granted, it will require significant adjournment, significant expense, significant resources to investigate and test something that we say is false. The prosecution have a bad track record. Let's not beat about the bush. They got it wrong for Mr Koski, they got it wrong for Mr Ali, they got it wrong for Mr Mathara, and they're saying, no, Your Honours, this time, fourth time lucky, we get it right. Your Honours need to be cautious about their protestations of certainty. They've got this case wrong. We say that the primary application, to use it for these ancillary purposes, should be rejected, and we'd urge you to grant, at most, what the defence for Mr Ruto put forward. What we hoped was a balanced and fair, in fact, bending over backwards to be fair to the prosecution approach, so that the witness can be tested for a limited purpose, and it will not necessitate this wild goose chase that the prosecution would have us embark upon. Your Honours, I'm grateful, and those are my submissions.
Thank you, Mr. Khan. Mr. Kigin-Katwa. First things, Mr. Kigin-Katwa, it looks like your written matter was filed out of time, wasn't it the case?
Yes, Mr. President, I propose to address that issue. Mr. President, may I start first of all by saying that I have reconsidered the filing I did on behalf of Mr. Sang. And I now take the position that we do not oppose, I do not oppose the use of the materials for purposes of challenging the witness if he has been found to be hostile. Your Honor, we will, of course, on our part, expect that a determination is made immediately before that material is used, that he has been deemed and found to be hostile. Your Honor, we are aware that our filing number 1407.
But you know, of course, don't you, that there is a difference between placing the materials on the list of the prosecution document, which largely serves notice purposes to you, versus actual use of any of those items when the time comes. We know that, don't we?
I do, Your Honor. Your Honor, just so that we are clear, we are saying we are not opposing to the inclusion of the list for purposes of the prosecutions in case they intend to use. We appreciate the difference, Your Honor. Your Honor, we would also like to indicate that on our part, we've raised in our filing that we have a certain concern, and we pray that in determining this issue, or even in the course of trial, that consciousness be placed on the issue as to whether the use of those materials could prejudice the interest of third parties to whom those materials make reference to. The prosecution in the argument have said that their desire is to present to the court the bigger picture, and the prosecutor has used the word mosaic picture. And much as we do not object to the inclusion of the materials to the list of items, we are concerned that in the course of it and in the process of trial, there is a possibility that third parties could be mentioned or affected or prejudiced in the event subsequent proceedings are conducted against them, particularly under Article 70. Your Honor, two last things I wish to mention. I propose to be very brief. Two last things I wish to mention. Your Honor, we are alive to the fact that we made our filing at 4 o'clock, our application number 1407. Your Honor, we were supposed to have filed that by midday, by 12 o'clock. Your Honor, we pray for the exercise of your discretion to admit our filing out of time in view of that oversight on our part. By way of explanation as to why that happened, Your Honor, it was simply an oversight on our part to notice that the time within which the filing should have been done was midday as opposed to 4 o'clock. And so, to that extent, Your Honor, we very much pray for exercise of your discretion to admit our filing. The last issue I wish to make reference to, Your Honor, is the matter that has been made, that Mr. Khan has made reference to, and that is the issue of witness number 16. Your Honor, it is indeed true that we wrote to the prosecution on the 25th of July 2014, 25th of August 2014, and the prosecution responded shortly thereafter. And in our inquiry, Your Honor, we highlighted the fact that the witness number 16 had very specifically said that most of what he had said in his original statements were untrue and that they were product of his own inventions. And we asked two important questions to the prosecution. The first one is what they intend to do with the fact that that witness had indicated that what he had initially said was not true. And the second one is what they proposed to do with him in respect to his status as a witness. Yeah, Your Honor, the prosecution, the third issue we raised, Your Honor, is that witness number 16, unlike all the witnesses we are waiting for, was willing to come and testify, Your Honor. The prosecution in their response, Your Honor, said that in view of their interest in investigating both incriminatory and exculpatory evidence, they are conducting investigations on what they refer to as newly evolving issues, and that they will come back to us, and that they intend to call him in the next session. Now, Your Honor, we submit that it is very telling that in coming before you and in justifying their intention to include these documents in their list of documents, the prosecution have said they are interested in giving you the bigger picture. Your Honor, in fairness, if they were honestly interested in giving the bigger picture, we submit, have expected them to include the presentations and the observations made by witness number 16. And witness number 16 has said exactly what we've always said, particularly in regard to Mr. Sang. He says, the question is put very directly to him whether he has been influenced or not. And he says he was not influenced. Further questions are put to him as to whether his change of position is because of influence. And he asks the prosecution, the first thing I inquire from you is, in my own statement, I have contradicted myself. Did I need to have been compromised to contradict myself in my original statement? One. Number two, if you are diligent, couldn't you have noticed that I have contradicted myself? Couldn't you have asked me to explain my contradiction? Your Honor, that is the extent to which this witness number 16 went. And this witness number 16 is obviously very intelligent. The question is put to him, and this is an...
Mr. King Kato, let's not discuss in further detail what it is that witness 16 said and is not. That's not said. In the public session, if you feel it is truly necessary for you to engage in that discussion, we will have to do it in private session. But it's for you to tell us if you consider it truly necessary.
With your permission, Your Honor, I am very much alive to the need for me to be careful not to say anything that is revealing of this witness.
Not just that.
Sorry, Your Honor, not only that.
Do you really intend, is it critical to your submission to engage in further discussion of what it is witness 16 said?
Only one item, Your Honor, and which in my view I can say in public. Only one item.
We will do that in private session. We'll go into private session now for 2 minutes, within which I hope Mr. Sang and Mr. King Kato would finish that discussion.
We're in open session, Your Honours.
Thank you. Mr. KenyaMOJA, please proceed.
Your Honor, in view of all the things I have said, Your Honor, it is our submission that, first of all, the witnesses or let me put it like this, Your Honor. We have no objection to these items being used, Your Honor. But we would like to raise the flag that, in fact, the prosecution have been selective in the material they have presented to you with a view to giving you a complete picture. The second issue we wish to say, Your Honor, is that the court, and we pray very much that the court remains alive to this, that it is possible, that it is true, that our narrative, that all these allegations against Mr. Sang and Mr. Ruto are false allegations fabricated by some individuals, Your Honor. That's all I wish to say.
Thank you very much, Mr. KenyaMOJA. Mrs. Steinberg, any reply?
Briefly on a few discrete points, Your Honours. I'll try to limit myself to the issues at hand here. I observe that my learned friends have rather used a scattergun approach in their responses, and as Your Honour commented, it sounded at some stages as if they were embarking upon their final arguments. But I submit the nub of the issue here is the relevance of this evidence, and I was rather distressed to hear my learned friend from Mr. Ruto describe these as a distraction and, in fact, as nonsense, if I heard correctly.
Correct. Distraction was the word of Miss Cynthia Tai.
Yes, with which I understand my learned friend said he agreed for once, strangely. Be that as it may, just to select one example, on the list of evidence which the prosecution seeks to lead are photographs of an occasion where one of the witnesses, I won't name them in public session, travelled to the protection location of another one of the witnesses and met with that witness for the purpose of conveying a bribe offer and said, why don't you accept this bribe like I did that has been offered by these people? You'll return to Kenya and have a comfortable life. Not only is he photographed, he's recorded in his own voice in an unguarded moment, laying out the basis of the scheme to corrupt not only this witness, but other witnesses. Subsequently, when he's confronted with this by prosecution investigators, he admits it. Is this a distraction? Is this not fundamental, Your Honours, to the determination of the credibility of this witness and other witnesses who have been targeted in this manner?
But as I understand the defense, I don't think that they're necessarily opposed to you confronting the witness on the stand with the materials you've indicated. Both of them have said they've no difficulty with you enlisting those items for purposes of confronting a witness on the stand. The question is about the bigger picture you're talking about. If that bigger picture goes beyond the credibility of the particular witness.
Your Honours, there is a principle in this chamber, in this court, that chambers should have the ability to freely assess evidence before them. And I would submit that unless it is absolutely necessary, chambers should refrain from trying to box off evidence and saying, well, we'll close our eyes to this aspect or to that aspect. Having said that, the prosecution does not intend to rely on this evidence to say that this proves that Mr. Ruto or Mr. Sang are guilty. But these are factors which the chamber should be free to take into account in the complex and difficult task which will face Your Honours at the end of this case in weighing the competing evidence which is before the court.
But it's always the case, isn't it, that in any criminal case, in most criminal cases, the issues are complex, and perhaps it could perhaps be for that reason that the concern against prejudice, evidence whose probative value is outweighed by prejudicial effect, is a cardinal principle in a criminal case. Here, the defense counsel is saying you're free to confront the witness with a document. Right. There may be also the broader question as to, well, if you successfully confront the witness with this document, is it necessary to do more than say, because we've shown that this witness cannot be believed on the basis of what they are saying, what they've said in court? Judges, we may urge you to give greater credence to what they had said earlier. Does the bigger picture need to be bigger than that? Particularly when you speak about the pattern of intimidation, a pattern of that's pervasive in the case, and the concern arises if you have not directly linked the accused person, directly or indirectly in a credible way, then it's such pattern. At what point do we start worrying that the bigger picture may in fact create prejudicial effects if you have not linked the accused person to it?
Your Honours, I submit that the prejudice is mitigated by the fact that the prosecution does not seek to use it to prove the guilt of the accused. And the chamber, being a chamber of professional judges, will disabuse its mind in the ordinary course of the evidence for that purpose. But speaking in hypotheticals, let's assume that we have a witness who testifies, who is recanted, who now testifies that in fact his original evidence was false. The prosecution relies on this evidence to challenge him and to argue that the chamber should accept his original evidence. The defense may, in the course of their case, call witnesses to testify about the fact that his original version was false and his subsequent version was true. If this evidence is only used for the limited purpose of considering the credibility of the prosecution witness, the bigger picture is lost. We submit that in weighing the competing evidence of the two witnesses, the prosecution witness being his recanted evidence, his original evidence, versus the competing evidence produced by the defense, this issue is a matter which will affect and is relevant to the probabilities and the probative value of the competing evidence. And that is what I'm referring to in the sense of the bigger picture.
That includes more or less a placeholder in case the defense does call evidence that may be considered against that bigger picture you're laying out. Is that what you're saying?
If I understand Your Honour correctly, yes. It's determining where the truth lies on the competing version of who's influencing who and for what purpose. I can't put it better than that. If I may ask to briefly go into private session just to raise for no more than 3 minutes to reply to my learned friend for Mr. Sang's submissions on witness P16.
Private session.
We're in open session, Your Honour.
Mr. President, with your leave, can I make just one point? I didn't make it clear, perhaps. I don't want it to be said that there's any inconsistency in the defence position regarding prejudice, that I'm content to show that we have nothing to fear, so that the Your Honours can assess evidence for the prosecution to be allowed to add certain evidence to its list of evidence, and then if a witness is declared hostile, or Your Honours say the witness is not desirous of telling the truth, the witness can then be confronted by it. And my submission that there will be massive prejudice regarding the other purposes for which the prosecution wished to lead the evidence. And the reason is simple. I'm not going to focus on that. If the witness, and I'll be quite plain about it, if a witness comes forward and sticks to the original narrative, I will test that narrative. My colleagues, my learned friends Mr. Ruto will test that narrative by evidence. If the witness recants and gives another version which repudiates the prosecution account, I will still stick to the original narrative to show it's false. And so I'm not going to embark upon resources on the Article 70. I'm not going to go there. I want to stick as laser-like as we're able to the PEV allegations. And that's why, Your Honours, in my submission, there's no inconsistency in my submission that it can be added to controvert the witness and for the other purposes. Because if the prosecution were granted leave to tender evidence for these ancillary purposes, of course I have an ethical obligation to investigate and test that evidence in order to investigate and understand that evidence so I can test it. If it's used for credibility, Your Honour, I'm not really largely going to go there. Maybe on one of few issues, if they arise, we may. But the primary strategy is to stick to the allegations of PEV, because we can show that they were absolutely nonsensical to start with. And, Your Honours, if we can satisfy you of that, Your Honours, really the case should finish as soon as possible. Your Honours, can I just say, I won't mention the name, but in relation to the witness that was mentioned in private session, it's only fair to say that when that witness was spoken to by the prosecutor, the witness...
No, the witness wasn't mentioned in private session. He was mentioned in open session, and we went into private session. So
okay,
if we're going to discuss it, we'll go back into private session. Back to private session.
I'm grateful.
We're in open session, Your Honours.
Thank you very much. We've had submissions on the matter of the ET documents that the prosecution wishes to add to its list of documents. The Chamber will render a ruling on the matter, certainly before the witness takes the stand. But that closes that item of our agenda for the day. Unless there is any other housekeeping matter.
Your Honour, just one matter. Yesterday I made an oral application that VW be ordered to disclose the expenses they have given the witness that appeared by video link. And, Your Honours, my learned friend who's not in court for the victim and witness unit stated that, as I understood it, that their preference was to give it to the judges and leave it for Your Honours to decide. Your Honour, my primary submission stands. I do say as a matter of fairness, that is information that should not be hidden from the defence. It can come to us without in any way jeopardising a witness, because we don't need to know, which hotel or which hospital or whatever, just the expenses that a witness has received, because to a witness's mind, whether it comes from the VW or the OTP, really is immaterial, particularly given the joint OTP registry protocol, and I would ask for that information. It will assist preparation. And Your Honours, if you can bear with me. Your Honours, I'm grateful to my learned friend, Mr. Hooper. That information, of course, is not binding on Your Honours, but it was disclosed to the defence in the Bemba case, and I'd ask that we be given it, not only because of Bemba, but on its merits, it's justified. I'm grateful.
Mr. Steinberg, any?
Yes, Your Honour. In fact, this is the very matter which was argued and ruled upon by the Chamber in respect of one of the previous witnesses. My understanding, and I haven't got the ruling before me, but my understanding was that the Chamber ruled that in the circumstances that the VW is an independent organ of the court, mandated to ensure that all payments are reasonable and necessary, that the limited forensic value of the disclosure of that evidence compared with the real issues of security that may be at risk, and plus the not insubstantial resources that will be necessary to conduct redactions where necessary, and I speak from experience about that, that the balance was that such materials should not be disclosed. So I'm not sure whether this is an application for reconsideration of that decision, or whether my learned friend seeks to distinguish that decision on the basis of some new factors or different circumstances relating to this witness. My understanding was that yesterday Your Honour's ruling was that this should be the subject of a written filing. Perhaps I was mistaken. Your Honour noted that Mr. Keegan Cutwer had indicated that he was to put in a written filing and that this should be dealt with together. I haven't prepared to argue this matter, but I'm speaking from memory. As a matter of principle, we would join the VW in opposing the disclosure of this information on the basis that it has very limited forensic value, and that having been paid and made by the VW, the Chamber should be confident in the fact that it was necessary and reasonable payments.
Mr. President, Your Honours, can I just say, I don't think there's an issue of joining VW, because VW yesterday did not oppose the application. They simply proposed a different avenue, that it should come to Your Honours first, and then Your Honours would decide if it comes to us. Your Honours, I'm not asking for even redactions of receipts and the like, just a schedule. I'll take them at their word, a schedule of what they say they've paid a witness. Your Honours, your previous, I don't think reconsideration comes into it, because I don't have the reference to hand, so I speak with a little caution. But my recollection was Your Honour was quite careful to say we're going to deal with this witness by witness on the facts. Now, Your Honours, on this particular case, the prosecution have said in relation to adding various documents that it's relevant as to why they recanted. Your Honours, given what my learned friend for the witness himself said yesterday regarding M-Pesa records and the like, Your Honours, we say it's relevant as to why statements, we say false statements, were given in the first place. So it's relevant to the issues. There's no amount of work to redact. It's a schedule. They should have it as a matter of good practice, how much they've spent on their witnesses. All I want is that the parties be given that. If it has forensic utility, we'll use it. If we won't, we'll use it properly and it won't come forward. But either way, it will not disclose anything that would jeopardise the witness, any locations and all the rest. And so, Your Honours, we say the balance is very much in favour of giving it to us. And it can be dealt with. We've got time. It's a very straightforward matter. I've got nothing more to say in a filing. It's a very straightforward matter. Given the issues the prosecution have raised in relation to recantation, we say it's relevant to the issue of an initial statement that we say is false and untrue. That may or may not be relevant to that issue. We've already raised the issue by the Council has raised the issue of M-Pesa records. It may assist the big picture that my learned friend was so keen about earlier in relation to the credibility or otherwise of the witness that will appear before you, and I say no more than that. It's easily achievable, and it's something the VW could prepare in 24 hours at most.
Mr. KenyaMOJA, when are you going to file your papers?
Your Honor, I expect to have filed it by midday tomorrow, Wednesday.
Yes, I remember you mentioning Wednesday. Can you not speed it up and file it today?
It's very unlikely today. Could I say by 9:30 tomorrow morning, Your Honor?
By 9:30 tomorrow
Yes,
morning,
yes.
okay. Yeah, do that. In the meantime, prosecutor, the chamber will recommend that you and Mr. Ken or the defense get together to see if you can come to an agreement on this matter.
Your Honour, in respect to this particular witness, there are circumstances which might permit us to do so. But what the prosecution is concerned about as well is that a schedule, as requested by my learned friend, may present a very misleading picture. If at the end of the day we have a figure, a sum of money that the VW has expended on a witness, and my learned friend stands up and says, oh, look, so many thousands of dollars or so many millions of shillings have been expended on this witness, it creates a misleading impression. This is not money going into the witness's pocket. This is money which is being paid, used to pay for necessary expenses.
But isn't it something you can argue at that point, assuming that if you have the ammunition to contain a misimpression that may be created by any use or arguments that might be made in that regard, you surely can also put your own arguments to right the ship, as it were.
It is possible, but that will mean then going behind those schedules and investigating each and every expense, painstakingly reconstructing what the purposes of those expenses were, to demonstrate what we already know, and that is that the VW, as an independent organ, does not waste the court's money. It spends the court's money as it has to do and as it determines reasonably under the supervision of the registrar.
Right. You have flagged now some of the possible misuses. We will not presume that the defense counsel will deliberately misuse information, but get together with the defense counsel and see what agreements may be reached without prejudice to Mr. KenyaMOJA's papers being filed. And if at the end of the day Mr. Ken says that's not good enough, then we'll take it from there. All right?
I'm most grateful.
As court pleases.
Any other housekeeping matter? We will be adjourning now, and we will reconvene on Thursday morning at 9:30. We will.
Mr. President, the only other issue, I understand summons have been served for 495, who's the next witness, scheduled to start next week. If we start on...
Sorry, it's scheduled on Friday, in fact.
On Friday? Yeah, Your Honour, on Friday of this week. So, Your Honour, we're going to have a bit of a scheduling issue. I presume it would be better, I assume, I may be wrong, to deal with the witness that appeared today. Could I ask for some, it can be done perhaps by the registry, that inquiries can be made so we don't have delay, that witness is he appearing alone? Is the witness having a lawyer? If the witness has a lawyer, make sure a list of counsel issues are sorted out. And then we have perhaps a renewed date. Your Honours may consider, given that summonses have been served, that one option is we can interrupt on Friday for a few minutes the testimony of the witness, almost so all parties can relax, so to speak, say this is not, trial will not start, the evidence, the testimony will not start on Friday of this witness, but have it almost for mention, so we can find out what is happening, and then give a new date when the substantive testimony of the next witness will start, and then we can focus, members of the team can focus then on that new start date. That seems to be a practical...
Let's not anticipate the problem before it occurs. That if the VW gets back to us or the registry, and if they report back that, yes, that we have a problem here, or on Friday, sure, then we'll deal with that problem.
I'm grateful. Thank you.
All right. We will adjourn for today, and we reconvene at 9:30 on Thursday.
All rise. We will